Hi, welcome back to Guardianship Information. This is session 3 out of 4. Again, my name is Irini Bekhit. I'm the supervisor of the Guardianship Department in the Surrogate Court of Richmond County. And this session will focus on the actual completion of the forms. So if you're now getting to this point, you have decided that 17A is the best route for you and your family. And what we're going to do now is actually just go over the paperwork. We're going to go over the paperwork one item at a time, one petition at a time, one document at a time. Don't forget, along with these videos, you're getting these documents in an email, so you'll be able to go through the terminology. If there's something I say that you don't understand, just refer to the terminology sheet. And we're going to go over the paperwork little by little, so you won't have we'll give you the best chance of understanding it. And don't forget, this is a recording, so if you want to pause it, rewind, go ahead. And if there's at any point that you have any questions, you can always give us a call at the Surrogate's Court. So let's get started. First, what I'd like to do is I'd like to do an overview of the terminology that I'm going to be using, as well as the procedure for going forward with petitioning. As you see here, the petitioner, if you're watching this video, chances are that's you. So you're the petitioner, you're the person asking relief from the court. So most situations that I've seen, it's the parent, one parent or both parents that are either the petitioners or one petitioner. So it's who is asking for relief from the court. The respondent is the person who is under a presumed disability. Now, this is all until the court actually says they're under a disability under 17A, but the respondent is the person you're trying to get guardianship over. An interested party is an immediate family member who has a right to object to the relief requested. For this particular set of papers, that's what interested party is. The interested party can mean different things in other contexts, but for your purposes right now, that's who your interested parties are. It's the people who have a right to object to the relief. So if we're talking, if you're the parents coming in, all siblings have a right to object. If you're a grandparent coming in, well, the grandparents on the other side also have an opportunity to come in. So it's anybody on that same playing field as you that has a right to come in and object to the relief that you're requesting. Waiver of process, renunciation, and consent to appointment of guardian is a document. It's actually one of the forms that we're going to go over, and it has to be completed by individuals who are closest to the respondent. So some situations it could be a parent, a co-parent who's not asking to be a petitioner, not asking to be a guardian, but if they're an interested party, then they have to give us a waiver of process, and it could also be any of the siblings in the household. A consent, oath, and designation. Anybody who is asking to be a fiduciary, whether it is a petitioner or whether it's a standby, an alternate, or a first alternate, they must fill out this form. It's the consent, oath, and designation. Why? You're not going to have somebody as a surprise find out that they're designated the standby. So in case the petitioners are not able to become the guardians for whatever reason, anybody else who's going to now be taking up a fiduciary responsibility must fill out this form. A citation is a document that has to be served, number one, on the respondent, but it also has to be served upon anybody who is an interested party who did not submit a waiver and consent. So we do a citation to make sure that all the interested parties have notice of this proceeding and that they're either consenting to the relief or, more importantly, they're not objecting to the relief. So interested parties are either going to fill out a waiver, or if you cannot get them to sign a waiver, then they have to be cited. The respondent always has to be cited. Okay, the 3909 is a form that we send up as part of the background check that we do. It is a little difficult to complete. What we ask you to do is gather the information, and when the time is right, we can work with you in actually completing it. We need a 28-year history of where you, as the petitioner, have lived, as well as any other co-petitioner and any adults living in your household. We have to know where they've lived the past 28 years. It has to be completed on the form, and then it gets submitted to Albany where a background check is done. Okay, so those are the forms and some of the terminology that you're going to need. The next thing I'd like to go over with you is now just general steps. Now, this all applies to the guardianship process in the Surrogates Court of Richmond County. This is how we do things. Different counties may do things a little bit differently. So what we ask and mandate is that you attend an information session. Right now, we are suspending the information sessions because of the COVID pandemic. So you're watching this video so you can learn and have an understanding about all your options and have an idea on how to fill out the paperwork. And what you need to do is, you can start this now, is by gathering these documentation. We're going to need this information in order to go ahead and at least get you started. So along with the petition and all the other documents we're going to go over, you also need an original birth certificate. And the original birth certificate is one that we keep. You do not get it back. You need your residential history for the past 28 years. You need 2 physician certifications, or 1 physician certification and 1 psychologist certification. That's statutory. The law says we either have to have 2 MDs or 1 MD and 1 psychologist. We cannot have 2 psychologists. Let me repeat that. We can have 2 MD certifications. We can have 1 MD certification and 1 psychologist certification. We cannot accept 2 psychologist certifications, okay? We also need an IEP, which is an individualized evaluation performance plan. It's an IEP or an ISP, or we need something that gives us an accurate portrayal of your family members' abilities. Okay, we need to have a clear understanding of what they can do or what they cannot do. And the filing fee for the court is it's a $20 filing fee. My apologies, a $20 filing fee, which is the filing fee for you to get the ball rolling. After you complete all the forms, generally speaking, you would make an appointment with the court so we can go over it. But right now, it's probably either you can make the appointment or mail in the documents to the courthouse. And once we review the documents, we'll let you know then if there's anything outstanding. Once the file is marked submitted and it's reviewed and it's good in a good form, then you can call the court and make a fingerprint appointment. Again, with the COVID pandemic right now, I don't know when you're going to be able to do that. But generally speaking, you and every adult in the household has to be fingerprinted. Again, that's part of the background check that we do. And you would have to call the main number in order to schedule that. But again, with the COVID pandemic, the building right now being closed, you're not going to be able to do this step. But again, the purpose of this information session is to kind of get you started, get the information that you need. That way when things are up and running, you'll be able to kind of jump on this and get this done. So once we, the court, review all the paperwork that you filed, we get the response back from the background agencies, then I generally am the one that reviews the file in its entirety to make sure that it's in proper order. Sometimes if there's something that doesn't seem right or something we need more information on, we'll call you in for a conference so we can go over some questions that we may have or some clarifications. What we try to do in the law department is we want to get this file in its best possible form before we can bring it to the surrogate, the judge, to decide what the next step is. You have to serve the citation, but you'll get a decision in the mail. We communicate in writing, so everything that we do with you is going to be in writing. So if there's anything outstanding, if we need a conference to be held, or if the matter is ready for a hearing, you get everything in writing. It tells you what the steps are, what the next steps are, so you just kind of have to be aware of that. If you do get a decision that gives you a hearing date, that's the final step. At the hearing date, the courtroom is closed to everybody except your family, and you will go to a hearing before the surrogate, and the surrogate will review the paperwork with you one more time, make sure that you understand the ramifications of what's being done, and it gives the surrogate an opportunity to meet your family and also ask questions to determine whether or not this is the least restrictive means available for you to ascertain your goals. The standard is the least restrictive means possible, so we have to see whether or not 17A is in fact the least restrictive means for your family to accomplish those goals. And at the conclusion of the hearing, the matter is marked decision reserved, and then you get, again, something in the mail in writing, either denying or granting your 17A application. And throughout the process, if there's ever any questions, you can always give us a call, send an email. ibeckett@nycourts.gov. That's I-B as in boy, E-K-H-I-T @nycourts, COURTS.gov. Okay, so that takes care of the terminology and the general overview. Now what we're going to do is we're going to go through the paperwork that you have to fill out. Again, in the email that you're receiving, you're getting two sets of forms, the mock forms and the blank forms. You can always get more blank forms if you go to the New York courts, this website right here, or this website right here. So if you type this in, highlight it, I'm going to try right now. Let's see here, copy, and let's go here. You'll actually get the forms that we're going over right now. So all you have to do is just take it from this cover letter that we're also sending you, and then just copy if you need more forms. But you're also getting the forms in an email, so it really shouldn't be a problem with that. Okay, so now what we're going to do is we're going to go over the forms, and what I'm going to do is I'm going to go over not the blank ones, but I'm going to go over the mock ones that were created for you. Okay, so the first thing that we're going to do is we're looking at the petition for appointment of guardian of person. The purpose of this information session is we're just concentrating on guardianship of the person and not the property. Okay, so you have to fill this out. This is the County of Richmond. If you're filling this out and filing it in Staten Island, you must be a resident of Staten Island, so you have to fill this part out, Richmond. Here is the name of the potential ward, right, until we adjudicate them as the ward. You know, they're just like you and me. So you would put the name of the person you're seeking guardianship over here. You would check the person right here, put a little X or a check mark right here. Here is, again, County of Richmond. You would fill that in. And then here you must read this. It says the name and permanent address, state, date of birth, and telephone number of the petitioners are as follows, and your relationship. So you also have to designate whether or not your loved one is intellectually disabled, is developmentally disabled. It could be one, could be the other, or it could be both. So you have to select which one is appropriate right over here. So put a little check mark right here. This section right here is the petitioners. So we could potentially have one petitioner. We could have two petitioners. So whoever it is would fill this out. So you put the name, telephone number, address, mailing address if it's different, the date of birth of the petitioner, and the interest. Who's the interest? Who's this person coming in and petitioning for these documents? Could be mom, dad, aunt, brother, sister, grandpa, grandma, whoever it is. You would state down the relationship. And then right over here is the second person, if it's applicable. So if you have two people applying to be petitioners and co-guardians, the second person's information would be here. The most common scenario that we see is when it's both parents applying. Now, number two is information pertaining to the person under a disability. So the name, the address, date of birth, marital status, and don't forget that you would attach a copy, the original birth certificate. So it's the original birth certificate or a certified copy of the birth certificate. Don't forget, it's not going to be returned. Page 2. Where is the respondent living? So if the respondent, the potential ward, your loved one, if they're living at home with you, then you just check off here. However, if they're living in a facility, this section has to be completed. Name of the group home, the address, etc., etc. If they're living in a home, the home has to be noticed, and so does MHLS, which is the Mental Hygiene Legal Services. They have to be given notice. So they either fill out a waiver of consent to the relief that's being requested, or they're cited, or you send them the petition once you're completely done with it, and you give us a document that says that they were served, that they were given notice of it, because they then have a chance also to object. They also become an interested party. Number 3, this information is about the parents. So it's the names and address, the names and permanent addresses of the parents of the respondent. And if the respondent is married, the spouse. So this section, it might be repetitive of page number 1, but who are the respondent's parents? Now, don't forget, every family is different. Every familial situation is different. This could be the same as page 1, and it could be very much different than page 1. So this section gives us, the court, information about the parent. So date of birth for the first parent, date of death if applicable. Same thing here, name of parent, second parent, and all this information, okay? This is a section only if it's applicable. If the ward, the potential ward, the loved one is married, then their spouse's information goes right here. Okay, next section. The names of the adult children and adult siblings 18 age or older are as follows. So here we need to know about all the siblings of the potential ward, okay, the respondent. All the siblings' information would go here. They would have to complete waivers and consents. You're going to see that a little bit later on. And if you're asking that one of the siblings of the respondent becomes a standby if you're not able to serve, then they also have to do an oath and designation, okay? But for purposes of the petition, we just need their names, relationship, and addresses. So you have up to 4 siblings that you can write down here. If there's additional siblings, just do that on an additional piece of paper, separate piece of paper. Number 5 is, who is the primary care physician? Okay, and this is, it doesn't matter if it's the person filling out those forms, the physician forms, or not, but we just need to know who the primary care physician is and their address right here. Now, you're only going to fill this out, number 6, if it's applicable. If the respondent's parents are both deceased, list the names of the nearest distributees. So if one parent is alive, you don't need to fill this. You only fill this in if both parents are deceased. Number 7, again, the names and address of the person whom the respondent resides with, if other than the parents. If it's not applicable, you just write not applicable, and if it is applicable, just complete this section. Number 8, if the respondent's parents, spouse, adult children, or adult siblings are living but not proposed to be the appointed guardian, explain why below. Does this apply to you? So if the petitioners or any siblings, adult siblings, are petitioning to be the guardian, this is not applicable. So if the parents or siblings are applying to become the guardians, this is not applicable. So this only gets filled in if the person who wants to be a guardian is not the parent or the sibling of the respondent. Number 9, this is an affirmative statement. Please read it and make sure that it is applicable. The person proposed to be appointed guardian, guardians, or standby or alternate are of sound mind, adult, and competent. Number 10, please, this is essentially what you're applying for, and then why are you applying for guardianship. So check off A and B for the person and property, check A for guardianship of the person only. This information session is just for the person only, so you could just check off A, and then you would tell us, hey, why are you requesting guardianship? Why is it that you want to be appointed the guardian for the respondent? Money here, again, this is information just concentrating on the person, not the property, so you can just put this as not applicable. Personal property, not applicable unless you're asking for guardianship of the property. Real property also not applicable in this particular guardianship information session. If there are assets and you are applying for guardianship of the person and property, then this information would be filled in. But depending on the property that you have, there may be other ramifications, which I'm not going to get into, like whether or not there's going to be government entitlements, whether or not you should be setting up an S&T. I'm not going to be giving you any legal advice, so if there is a large amount of assets that belong to the respondent, you might want to seek the advice of counsel on how that should be handled. Right now, chances are you are the designated payee of SSD, so you could just fill this information, but you do not need to be appointed guardian of the property to collect the SSD benefits. Why? You're the payee, so we don't count that. That's not something you would just fill in that applicable section right here, but you don't need to be guardian of the property for the Social Security disability benefits, okay? That's not applicable. The next section here is now the 2 names of the physicians those documents are going to get completed, and the dates, what they're dated. It has to be really within 6 months of when you're filing. So make sure once you get these physician documents that you file them with the court along with the petition. Also, don't forget to check these two, intellectual disability or developmental disability. It could be one, the other, or both. Again, as you can see here, number 13, if this is for limited guardian of the property, chances are this is not. We rarely see this. Number 14, the names, permanent address, dates of birth, and relationship of the guardians are as follows. Name of the guardian if other than the petitioner. So if you're the petitioner and you're filling out this paperwork, you don't need to fill this part in right now, because the petitioner is asking to become the guardian. You don't need to fill this in. If the petitioner is completing paperwork and asking that somebody else be appointed the guardian, rarely happens, but it could, then this part would be filled in. Next section is now the standby guardian, okay? So the standby guardian is the person who steps up if one or both guardians are no longer able to do so. So if you're petitioning for co-guardians, 2 people to act together, one of them is still the guardian even if one passes away or is not able to act. The standby guardian only steps up when there are no guardians available. So if both guardians have passed away or they're no longer able to serve, then the standby can step up. The standby has 180 days to confirm his or her appointment as standby in order for it to be effective. They can act within the 180 days, but then they still have to be confirmed. Separate application, but a lot less intrusive than this. But this allows you a pecking order. So you have the guardians, then you have the standby guardian, then you have the first alternate standby guardian, and then the second alternate standby guardian. So again, it's a pecking order. You have your guardians first, then your standby, then your first alternate, and then your second alternate. The second alternate only steps up if there's nobody else that's able to serve prior to that. Okay, so it's a pecking order, just so you can have a lineup of who can step up if need be. Okay. Number 15, check one of these. You read it. Again, it's up to you. You can decide which one is best suited for your situation, but just so you're aware, usually the surrogate will determine whether or not the respondent has to appear for the hearing or not. So you can select whichever one that you want, but it's up to the surrogate to determine whether or not attendance would be required at the hearing. Number 16, you need to read it and make sure that this is applicable to you. Number 17, petitioner, select one. Does have knowledge, does not have knowledge that anybody is the subject of a child abuse and maltreatment registry or has ever been the subject of child protective proceedings. I just want to take a moment to say that you need to be honest when filling this out, because when we do our background check, we do find the answers. Even if there was an incident that happened and it was unfounded, you still need to let us know, and you'll probably have that letter that says it was unfounded, so then you would just submit it and explain it ahead of time. Number 18, you have completed, again, this is the background check, the 28-year history. Number 19, to select which one is applicable. The respondent is or is not a Native American child under the Indian Child Welfare Act of 1978. Pick one. Is it applicable? Is it not? This is also a statement that you're reading. There are no other persons interested in this proceeding under whom process is required other than those listed above. This is an affirmative statement telling us that you have given us all the information that we need to determine who are the interested parties, all the people that have a right to object, or that are needed to consent in order for this to move forward. Number 21, no prior application has been made to this court except, have you come in here and tried to apply for guardianship in the past? If so, list it down. If not, just write none. Okay, this is the most important sheet because now this is your relief. This is what you're asking the court to look into and grant. This is your bottom line. This is everything what it accumulated to. Here is your wherefore clause. You are asking the court to grant this relief. Who do you want letters of guardianship to go to? guardianship of the person belonging to the petitioner, guardian, whoever the person or persons are. Appointment of so-and-so as the standby, if you have a standby. So-and-so as the first alternate. So-and-so as the second alternate, if you have these people lined up. We strongly recommend that you have your lineup ready as much as possible. You can always change it later on, but it's better to have something in place and then amend it later on rather than have nothing and then be in a situation where then somebody's scrambling to step up to the plate if it's absolutely necessary. This is again, you're going to check off, select one, whether or not the appearance of the respondent should be or should not be required. Like I mentioned before, you can make your selection, but it's up to the surrogate to make a determination here. This is an affirmative statement that you're going to read. This is not applicable unless there's funds here. This is an affirmative statement. And then if you have any other relief that was not mentioned here before, okay? And then you're going to sign, and this has to be notarized. Here is the combined oath and designation. So if you have one petitioner, one guardian, this gets filled out. If you have two people applying to be guardian, you need two of these pages. So both petitioners have to fill this out. You can actually do it on the same page. You have room here for two people to sign it, and it just has to be make sure that the notary lists both people that are signing it. So you can either do one page or two pages separately, but this does allow you two people to do it. This does not come into play because this is a corporate consent. So unless you have a corporation acting to be guardian, then this would not be needed. Okay, so that takes care of the petition. That was the longest of all the paperwork. So if you've made it this far, take a deep breath. It's okay. The rest of the documents will certainly not be as detailed or involved. Okay, so next document is the affidavit of proposed guardian of the, again, person. This should be completed by the petitioner, the person who's asking to be guardian. So if we have one person coming in to be the guardian, only one person needs to fill out this form. If we have two people, then both people individually must fill out this two sets. Again, county goes here, the name of the respondent goes right here. County again, the name of the respondent goes here. This is, I'm a competent person and I am trying to become guardian of intellectually disabled, developmentally disabled. Make sure you check off one or both, whichever is applicable. This is simple. This form is a pretty simple one. I have known the subject respondent since when? Is it since birth? Is it since you've been taking care of this individual? Whatever the year is, list that down here and list the relationship that you have together. List where you reside. This is your address. And now you're listing all the members of the household, not just 18 years old. So all the residents of the household go here. We need their dates of birth and we need their full names. Your educational background as the guardian, the petitioner, goes here. This is important. Again, this is disclosure, not including minor traffic offenses and adjudications as a youthful offender or a juvenile delinquent. I have never been convicted of an offense against the law except I've never forfeited bail or collateral except. Disclose whatever it is because we're going to find it out anyway. So disclose it and explain it. It's up to the surrogate to make the determination as to whether or not this would prevent you from becoming guardian. Again, there's a little note here. Make sure to complete every question. If there's something that's not applicable, you can write so. But for these questions, you shouldn't be writing not applicable. You should just write none. Okay, you're making an affirmative statement that there is none. I do not have any criminal charges pending against me except if there is something, write it down. Otherwise, write none. I have no physical or mental impairment that would interfere with my ability to become the guardian of the intellectually disabled person or the developmentally disabled person. Check off one, the other, or both. This is an affirmative statement. You're not addicted to narcotics or alcohol, that you're willing to serve to become the guardian. And again, why you believe you being appointed as the guardian is in the best interest of the respondent. So you put your reason right here. You would sign it and it would be notarized. Again, if there's one proposed guardian, only one of these has to be filled out. If there's two, both people have to fill it out. Okay, So here's your the second one. This should be completed by the second petitioner, co-guardian if applicable, only if it's applicable. Next, we have the consent, oath, and designation. So every person that is seeking a guardianship fiduciary status has to fill this in. So the petitioners have already filled out the consent, oath, and designation on the original petition. It was that one of the last pages on that petition. So now who fills this out? It's your standby, it's your first alternate, and it's your second alternate. Anybody who is consenting to become a fiduciary completes this page. Again, Surrogate's Court, County of Richmond, the respondent's name here, county of, wherever now they're filling this out, the name of the person, and they're consenting to their appointment as, if this is the one for the standby, they would check off standby, person. Again, here I immediately assume the duties of guardian of the person, and will seek to have the court confirm my appointment within 180 days, and then oath of standby. So it's got to be consistent. So if you're the standby here, you put down standby here, and you are saying that you are faithfully going to discharge your duties of standby of the person, and you're going to designate Richmond County, the surrogate's court here, for service of process if you're not able to be served, your address as the standby, and the proposed signature of the proposed guardian here gets notarized. Okay, so you would do one of these for every fiduciary status. Same thing then would go apply for the first alternate. First alternate, person, person, first alternate, person, county. Make sure everything gets filled in. First alternate, address, signed. Okay, so one of these needs to be completed for every person asking for a fiduciary responsibility. Now, waiver of process. Interested parties are going to complete this section. You may have a situation where you might have the interested parties are also going to be taking the position of a fiduciary responsibility. They would fill out both forms, the waiver and the oath and designation, because they're filling this out in the role consenting to you becoming the guardian. They're a sibling. So if you have a sibling of the respondent, they're an interested party. They have to fill this out. And they're saying that I have no problem with mom and dad or whoever it is acting as guardian. And the other sheet here, it is I'm also consenting to become the standby if mom and dad are no longer able to do so. Okay? So now let's go over the waiver of process, renunciation, and consent. So same thing here, county, Richmond, guardian, the respondent's name, the undersigned, the name of the person filling this out. So this would be any interested party. So if you have parents and the respondent has siblings, every sibling has to fill this out if they're 18 years of older. If you have grandparents filling it out, well, the grandparents have to fill it out. Grandparents on the other side have to fill it out. If you have an aunt or an uncle, all the aunts and uncles then have to fill it out. So it's everybody on that same playing field, as well as anybody that's close to the respondent themselves. So if the respondent has siblings, and the siblings are not coming forward to become the guardians, but an aunt or an uncle is, so all the siblings have to fill this out, and now all the aunts and uncles have to fill this out as well. Because why does one aunt get to become the guardian to the exclusions of the others? So everybody on that same line, that same relationship status, has to fill it out. So the undersigned name, whose permanent address goes here, and then you would list the interest. So this is a sibling. We just check off adult brother or sister of the above named intellectually, developmentally disabled person. Here you're just putting in the relationship of the person completing this form to the respondent. It could also be a parent. If you have one parent asking to become the guardian and the other parent has not been in that person's life, so maybe they're also filling this out, that they're consenting to mom becoming the guardian. They're the father or the mother, but they're not going to become a guardian. They don't want to be a guardian, but they would still have to fill this out. as the parent of the person. If they're the spouse, adult child, sibling, whatever that relationship is, they would have to fill this out. They're also now renouncing the right to apply as guardian, waive the issue and service of process, and consents that the names of the people asking to become guardians of the person, consenting that so-and-so be named as the standby guardian, so-and-so first alternate, so-and-so second alternate. So the person who's filling this out has an interest where they could potentially become the guardian, but they're saying, I don't want to be the guardian. I'm consenting to all this other people becoming guardians or standbys, myself maybe perhaps included. So it's a waiver, it's an agreement, it's a agreement that other people are becoming guardians, and it's just waiving their right to become guardian at that particular time. And it's a consent to all these other individuals stepping up and filling in those roles. This has to be signed and this has to be notarized. And this has to be filled out by every interested party, okay? Every interested person fill this out. This is a document that's given to the MD. So the MD has to complete this. Make sure county, the name of the ward is filled in. The respondent goes right here. We've gotten forms back where the guardianship, the respondent's name is not listed. I can't accept them. Why? Because I don't know who this physician is filling this paperwork for. It could be for somebody else. I don't have any other way to tell that this document is being filled out for a particular person. So make sure that it's completely filled in. And I know that physicians are very, very busy and they have a lot on their plates, but please make sure that everything is filled in. And what is their professional background? Is it in this type of disabilities or this type of disabilities? What gives them that professional background? What is their experience? Their experience should be listed here. When did they examine the respondent? This has to be filled in. Everything has to be filled in. As you can see, it says in the document set forth in detail the names and addresses. One word is not detail, okay? The mental physical condition of the respondent. Please, this is very important. Describe in detail. Don't forget, the ultimate goal of 17A is you're asking the court to take away somebody's rights from now until the end of time. So if we're taking away somebody's rights from now until forever, then we need to make sure that the documentation warrants such an extreme measure. So everything has to be filled out properly and completely. Intellectual disability, if the person is suffering from an intellectual disability, this would be checked off. And why? If it's a developmental disability, which one? There's more here. Okay, and again, there's room for detail. If it's both things get checked off. Again, one of these is checked off. Number 8, one of these is checked off. So everything has to have something checked off. There's an appropriate circumstance. So before you leave the doctor's office, make sure that every question is completed. Number 9, select. This is only applies if it's an intellectually disabled person. This one is checked off if it's a developmentally disabled person. If in the forefront here, they're saying that there's only one, it's intellectual disability, then that only has to be filled out, the intellectual disability portion. If the physician is saying there's an intellectual disability and a developmental disability, then it has to mirror that. That also has to be filled in, both of them. Signature of the physician, because it's an MD, we do not need a notary, signature is enough. The next one is essentially the same, but this is now for the licensed psychologist. So if you have an MD filling it out, then that's fine, the second person, or the psychologist can fill this one out because it allows them to. Same thing as before, everything has to be in detail completed. What is great usually about the psychologist reports is that they have reports and other documentation that they usually provide along with this. These two documents on their own are not sufficient, so you have to have the tests, whether it's the Stanford Binet or the IEP or the ISP, something else has to go along with these two documents when you're submitting it. So again, we have a better idea of the respondent's abilities. Okay, this is the citation. Don't worry about the citation. We actually will fill it out. We will prepare it for you when it's time to serve the respondent. However, if there's other people who are interested that are not consenting, then you're going to have to do this on your own, because if it's a contested matter, we cannot help. So here you would just put the person's name who you're trying to get jurisdiction over. So let's say you have a co-parent or a parent of a child who's not cooperating. You're not able to get that waiver and consent from them. They're not asking to be a co-guardian. Well, then you would put their name here, and you would mail them a copy of the petition along with the citation. And the citation is, we issue it out. We let you know when you have that hearing date. That's when you get this as well. So you can always add the person's name to it. It's going to have a date and an address of when you have to appear in the court. So this kind of goes along with the hearing date, because that tells people who are receiving it that there's going to be a hearing on such and such a date, and if you have any objections, you must come in on that day to voice that objection. But again, 99% of the time, guardianships, we fill this out for you because they're not contested. This is the 3909 form. What we ask you is to just get the information for the 28 years, maybe even write it down on a separate piece of paper. And if you're not able to come in and make that appointment, just write down all the maiden names of the people in your household, all the people in the household, write it on a different sheet of paper, and write down, give us the information, the sex, the dates of birth, and the addresses. And we need the month and the year, okay? We need the month and the year. If it's not filled out properly, it's going to get rejected. It's going to get sent back to us, and that's going to delay your petition ultimately. And that's actually it. That's all the paperwork that would need to be filed with the surrogate's court. I hope that this has been an informative session for you. Again, if there's anything that was not clear, try to watch the video again, or just shoot me an email, ibeckett@nycourts.gov. Thank you for watching segment 3. I'm now going to do the last recording, which is commonly asked questions, so stay tuned for that.